The appellants brought a negligence action against the appellee for injuries sustained in an automobile accident. They requested that the jury be instructed that it could award damages for loss of capacity for the enjoyment of life, loss of consortium, disability, and disfigurement, even if it found that the permanency threshold of the Florida motor vehicle no-fault law was not satisfied. The trial court denied the requested instruction, and the jury ultimately returned a verdict in favor of appellant Gail Giles. However, because the jury found that she did not suffer a permanent injury, it awarded her only the amount of her unpaid medical expenses. The appellants filed this appeal asserting that the trial court erred by denying their requested instruction. We affirm the final judgment, but we certify a question to the Supreme Court. Section 627 provides, in pertinent part, that every owner, registrant, operator, or occupant of a motor vehicle for which security has been provided as required by the no-fault law is exempted from tort liability for damages because if bodily injury occurs, sickness or disease arising out of the ownership, operation, maintenance, or use of such motor vehicle to the extent that personal injury protection benefits are payable for such injury unless a person is entitled to maintain an action for pain, suffering, mental anguish, and inconvenience for such injury under the provisions of subsection 2. Section 627 provides, in pertinent part, that in any action of tort brought against the owner, registrant, operator, or occupant of a motor vehicle with respect to which security has been provided as required by the no-fault law, a plaintiff may recover damages in tort for pain, suffering, mental anguish, and inconvenience because of bodily injury, sickness, or disease arising out of the ownership, maintenance, operation, or use of such motor vehicle only in the event that the injury or disease consists in whole or in part of a significant and permanent loss of an important bodily function, b, permanent injury with a reasonable degree of medical probability other than scarring or disfigurement, c, significant and permanent scarring or disfigurement, or d, death. The appellants assert that a plain reading of the statute establishes that non-economic damages are not included in the tort exemption of Section 627. Therefore, they argue that the threshold requirements in Section 627 apply only to those four non-economic damages specifically listed: pain, suffering, mental anguish, and inconvenience, and all other non-economic damages available at common law and not listed in the statute are recoverable without a threshold injury. The second and fourth districts have addressed and rejected this argument. Smiley versus Nelson, 805, Southern Reports, 2nd, 870. Florida 2nd, DC, 2001. In Smiley, the 2nd District reasoned that the tort exemption in Section 627 extends to all damages, economic and non-economic, and the 4th District adopted the 2nd District's reasoning in Gill and Welch. After reviewing the statute and the relevant case law, however, we agree with the appellants that the exemption does not apply to non-economic damages because a defendant is shielded from liability only to the extent that PIP benefits are payable for a qualifying injury. See, for example, Auto Owners Insurance Company versus Tompkins, 651, Southern Reports, 2nd, 89. And PIP benefits are not payable for non-economic damages. Although this interpretation brings into question the language at the end of Section 627 that a tortfeasor is exempt unless a person is entitled to maintain an action for pain, suffering, mental anguish, and inconvenience for such injury under the provisions of subsection 2, we conclude that the legislature merely intended by this language to emphasize that intangible damages would be recoverable under certain circumstances.
You're right, intangible.
2 strokes.
Yeah, me too. Oops.
How do you get that?
Okay.
$130. Hold on.
Yeah. Should I put Tompkins into my dictionary?
What?
Tompkins, the name.
Yeah. Because it's a bunch of spellings. T-O-M, T-H-O-M.
What about Welch?
I never put any names in my dictionary, but if you want, if you think you're going to get Welch again, I mean, it's names are too many. Got a whole phone book here.
How do you write adopted 3 strokes?
Yeah. I mean, you might get away with D-O-P-T, but I wouldn't remember. And if you had an adopted, you don't know what's adopted, an adopted, or adopted. Want to read some?
Okay. The appellants brought. Oops, I forgot